Beastie Boys formed in New York City in 1981. They were a groundbreaking group that helped bring rap to mainstream audiences, consisting of Michael Mike D. Diamond, Adam MCA Yauch, and Adam Adrock Horowitz. The group started as a punk rock band before transitioning to rap. They achieved massive success with their debut album Licensed to Ill in 1986, which became the first rap album to top the Billboard 200 chart. One of the tracks on Licensed to Ill was a song called Girls. It was a short comedic hip-hop track that lasted just over 2 minutes. The song featured Adrock rapping about his desire for women with a simple electronic keyboard melody and drum machine beat. While the original lyrics were considered misogynistic by some, Beastie Boys maintained that the song was meant to mock such attitudes in rap music. The song was the 7th and final single released from the album. That should give you an idea of just how successful the record was. You normally don't see 7 singles released from one album. Adrock wrote the track with producer Rick Rubin on the train to Washington, D.C. Rubin told Newsweek in a 2013 interview, "We started with the idea of what the song would be. It was rooted in the Isley Brothers' Shout. What would a rap version of Shout sound like?" he asked. And if you listen to it now, you'll see it's really similar. The company Goldieblox opened its doors in 2012 after generating more than $1 million in pre-orders on Kickstarter in just its first month. Goldieblox produces toys that introduce engineering concepts to young girls. The company went on to sell its products to big retailers like Toys R Us and the mega giant Amazon. A year after opening its doors, though, the company found itself in legal trouble with Beastie Boys. But maybe the whole thing was planned from the start to gain a ton of publicity to help boost sales. It certainly seems that way when you dig into the facts. Goldieblox used a parody version of Beastie Boys' song Girls, altering the lyrics in an advertisement that quickly went viral.
Goldieblox wants to see girls doing this.
Girls build a spaceship, the code's a new app.
The video featured young girls using Goldieblox toys to create a Rube Goldberg machine. Soon the advertisement got on the radars of Beastie Boys and their lawyers. Beastie Boys had long objected to the use of their music in advertising. They cited a provision in the late Adam Yauch's will, which prohibited such use. Yauch passed away in 2012 due to cancer. In a strange twist though, Goldieblox initially filed a preemptive lawsuit against Beastie Boys first, claiming fair use since their version of the song was a parody. Vulture.com covered the story and interviewed a copyright lawyer about the whole situation, and they shed some interesting light on the whole thing. The lawyer is an attorney named Stephen M. Iyer, who remarked, "My personal take on it is that this legal case is a piece of their marketing plan when it comes to this video. The Beastie Boys are well known for the fact that they don't do any advertising, and Goldieblox never asked for the license. They had this mega law firm Orrick conveniently on standby, so that as soon as any sort of threat or demand came through, they could file a suit." He went on to add that Goldieblox changed the law firm that they were working with to a smaller company who deals with information technology litigation. This same company represented Google when they were sued over Google Books. If you guys have ever checked out Google Books, it displays snippets of published works without the author's consent. Google ended up winning their case since people can't read the entirety of the published works. That lawyer Iyer added that during the discovery stage, Goldieblox will have to release all their emails with their marketing team, and that the truth would ultimately come out about the company's real intentions. So Goldieblox claimed that their parody of the Beastie Boys song Girls falls under fair use. Fair use is a legal defense in the event that you're sued in court over copyright infringement. You don't really know whether something is truly fair use unless you get taken to court, and fair use is something that is examined on a case-by-case basis. That's at least how lawyers have explained it to me. But fair use in simple terms allows a party to use a piece of copyrighted work, whether it's a TV, a movie clip, part of a book, or in this case, a song, without the copyright owner's permission, provided that it's transformative in some way, like providing criticism, doing a parody. It's for research purposes, commentary, news reporting, or teaching. There was some precedents from a previous court case that happened nearly 2 decades prior. We'll talk about that in a bit. Goldieblox also argued that they were entitled to use the song because they were promoting a good cause. In reality, the courts don't really care whether it's a good cause or not. This is where you might have seen a lot of politicians get in trouble with musicians. You've read about political candidates receiving cease and desist letters from musicians to stop using their music in marketing or campaign rallies or in commercials. But the politicians sometimes claim they're protected by fair use. Probably the best known recent case involves former President Donald Trump, who had to pay out a good amount of money for using an Eddie Grant song without authorization. Other artists have filed lawsuits against Trump, including Jack and Meg White of the White Stripes. But as we all know, things move very slowly in the courts. It's not just political candidates who've gotten in trouble, but hockey teams as well. Beastie Boys responded to Goldieblox's lawsuit with their own lawsuit claiming copyright and trademark infringement. The rap group claimed that the toy maker's use of the song didn't constitute fair use, as the ad used the Beastie Boys musical composition, and that the song was modified to become a jingle to sell Goldieblox's products. In their complaint, the Beastie Boys also claimed the original lyrics were sarcastic to begin with, and this is where things get a little complicated. Goldieblox's fair use defense might have fallen apart. That lawyer I referenced earlier added to Vulture, but my impression of the original song has always been that it's so over the top that seems to be a commentary unto itself on that macho party lifestyle of most hip-hop bands at the time. And so the complaint and all the publicity coming out from Goldieblox about it seems to be, this is an incredibly sexist song, and so we are parodying it because we are trying to advance the cause of women in the STEM fields. But I think that argument fails if the song at the heart of it isn't really as sexist as it would be if you took it literally. While the copyright infringement case may be obvious, Mr. Iyer added that the titles of Goldieblox's videos on YouTube and in social media contain the terms Goldieblox, Rube Goldberg, and Beastie Boys. He added, so the trademark claim really goes to whether or not Goldieblox was falsely associating themselves with the Beastie Boys or falsely indicating that the band had in some way endorsed this or were on board with it. If nothing else, they certainly tried to make it so that all their marketing efforts were very SEO friendly when it came to the Beastie Boys. He went on to add that the company might be more guilty of trademark infringement than copyright infringement. Earlier in this video, I had mentioned a court case dating back 2 decades prior that set some precedents when it came to parodying a song. There was a case dating back to the early 90s that was ultimately decided in 1994 that involved rap group 2 Live Crew and Roy Orbison. 2 Live Crew released their hugely controversial third album in 1989 as Nasty as They Wanna Be. The album was so controversial that the United States District Court for the Southern District of Florida deemed it legally obscene, and I kid you not, guys, the police were arresting record store owners for selling the album. It's the first album in history to be deemed legally obscene. Then on June 9th, 1990, 3 members from 2 Live Crew were arrested when they performed some of the songs off the record at a strip club in Broward County, Florida. They were eventually acquitted on all charges. So let's get back to the 2 Live Crew lawsuit. On the record as Nasty as They Wanna Be is the track Pretty Woman, which is a parody, of course, of the Roy Orbison song. You can probably tell where I'm going with this. The rap group also sampled Roy Orbison's composition, and when 2 Live Crew tried to get the rights to sample the song, the publisher who owned Pretty Woman, A Cuff Rose, basically refused the license. However, 2 Live Crew still sampled the song and put it out on their album, and after it sold about 250,000 copies, the publishing company at Cuff Rose hit 2 Live Crew with a copyright infringement lawsuit. The case went all the way to the US Supreme Court, and 2 Live Crew won after the judges ruled that their parody of Pretty Woman fell under fair use. Therefore, 2 Live Crew escaped any liability. The courts, when evaluating fair use, always look at 4 factors. Number 1 is the purpose and character of the use, including whether such use is of commercial nature or it's for non-profit or educational purposes. Something can still be commercial and be considered fair use, but it seems like if it's non-profit, it stands a better chance of being fair use. Number 2 is the nature of the copyrighted work. Number 3 is the amount or portion used in relation to the copyrighted work as a whole. And number 4 is the effect of the use upon the potential market for or the value of the copyrighted work. So Goldieblox's lawyers likely knew about this case. While a parody can be considered fair use, just because it's a parody, it doesn't automatically qualify for fair use. Eventually, in March of 2014, a settlement was reached between Goldieblox and Beastie Boys. You have to remember, Goldieblox isn't a very big company, and they probably didn't want to face hefty legal bills. As part of the settlement, Goldieblox apologized on their website and paid a percentage of the revenues to several charities that were selected by Beastie Boys. These charities focused on science, technology, education, and mathematics for girls. The lawyer I referenced earlier told Vulture that the parodying the song was probably part of the company's marketing plan, with him adding, "It almost feels like reverse copyright trolling, like they tried to bait Beastie Boys into a situation where they could be sued, especially considering the Beastie Boys are known for being feminists." Now let's talk about the elephant in the room. You're maybe saying, but Sid, Beastie Boys sampled other artists' work on their music. So yes, Beastie Boys have faced legal action over their own albums which feature samples. Perhaps one of the most recent lawsuits happened in 2012, which was brought against the band by a company named Tough America, claiming to own the rights to several samples that were used on Beastie Boys' early albums. Ultimately, the lawsuit was thrown out not because of fair use, but because Tough America didn't own the exclusive rights for some of the samples that were named in their lawsuit. As for whether it's hypocritical of Beastie Boys to sample other people's music without clearing them, that same lawyer I previously mentioned told Vulture.com, from a legal perspective, yes, you're dealing with all the issues of copyright infringement. I think from a moral and artistic perspective, the Beastie Boys would say that it's completely different, and I would probably agree with them. Whatever you think about sampling, it ultimately comes from an artistic place. It's about creating a new creative work. That does it for today's video, guys. Thanks for watching, and we'll see you again in Rock Culture Stories. Take care.